Hello, everyone. I'm Anu, an engineer and a law graduate, and I welcome you to my channel where law meets logic and learning becomes easy. Welcome back to part 2 of our environmental law series. In this video, we'll be diving deeper into two powerful legal tools that play a crucial role in protecting our environment in India: the Criminal Procedure Code, CrPC, and Public Interest Litigation, PIL. Whether you're preparing for exams or just eager to understand how the law empowers citizens and authorities to fight pollution and safeguard nature, you're in the right place. Let's continue where we left off. AD Criminal Procedure Code is CrPC for combating environmental protection and development. Introduction. Environmental protection is typically associated with specialized statutes such as the Environment Protection Act 1986, the Air Act 1981, and the Water Act 1974. However, the Criminal Procedure Code 1973, CrPC, though a procedural statute, plays a vital supplementary and enforcement role in combating environmental degradation. The CrPC provides preventive, remedial, and punitive mechanisms for environmental harms through the powers vested in executive magistrates and the police. These provisions empower authorities to take immediate and effective steps in case of public nuisances, hazards, or threats to public health, many of which arise from environmental issues. Relevance of CrPC in environmental protection. Though CrPC is primarily concerned with criminal justice, it plays an indirect yet powerful role in environmental governance by preventing environmental nuisance or harm, providing remedies against public health hazards, empowering magistrates to issue orders to prevent danger to life or property due to environmental degradation. The key provisions of CrPC relevant to environment protection. Section 133, Conditional Orders for Removal of Public Nuisance. Text of provision. Section 133 empowers district magistrates, subdivisional magistrates, or executive magistrates to issue conditional orders for removal of public nuisances. Scope for environmental protection: air and noise pollution, water contamination, industrial effluents, open drains and garbage dumping, unauthorized constructions affecting natural water flow. The magistrate may order removal of such nuisances or abatement of pollution. Non-compliance can lead to prosecution under CrPC and even imprisonment. Case law: Municipal Council, Ratlam v. Vardichan, 1990. A landmark judgment by Justice Krishna Iyer. Residents filed a complaint under Section 133 due to open drains, overflowing sewers, and filth. The Supreme Court directed the municipality to clean and maintain sanitation using Section 133. Held, the provision can be used as a tool of social justice for environmental and public health protection. Section 144, Urgent Orders to Prevent Danger. This section empowers the magistrate to issue urgent orders to prevent obstruction to persons lawfully employed, disturbance of public tranquility, danger to human life, health, or safety. It is often used during pollution emergencies, e.g., industrial gas leaks, toxic dumps, or mass protests against deforestation or industrial siting. Application: preventing construction in ecologically sensitive areas, restricting gatherings in areas prone to air or noise pollution, emergency orders against illegal mining or sand quarrying. Example: during the Delhi pollution crisis, several district magistrates imposed Section 144 orders restricting burning of biomass and construction activities in high-risk zones. Section 145, Dispute relating to land or water. This provision is useful when disputes arise regarding rights over land or water, especially in environmental contexts. Examples: disputes over pond encroachments, illegal landfills on community lands, damaging common water sources through toxic dumping. Powers granted: magistrate can determine possession, can issue temporary restraining orders, prevent ecological harm due to encroachments or land misuse. Section 268, Public Nuisance, read with IPC Section 290-291. CrPC's Section 268 defines and provides procedural remedies for public nuisance, which includes emissions from factories, obstruction of roads due to construction debris, dumping of waste in water bodies, punishment, fine under Section 290 IPC for creating public nuisance, enhanced penalties under special environmental laws. E. Section 482, Inherent Powers of the High Court. This section grants High Courts inherent powers to make orders to prevent abuse of the process of any court, secure ends of justice. It has been used in environmental matters to quash proceedings that harm the environment or to intervene in interest of public safety. Example, High Court stays illegal construction in reserved forest or wetlands even before a case is heard fully, using inherent powers under Section 482. IV. Integration with Indian Penal Code (IPC) provisions. While CrPC is procedural, its effectiveness lies in enforcing substantive laws such as the IPC, particularly Section 268 IPC, Public Nuisance, Section 277 IPC, Fouling of Public Water, Section 278 IPC, Making Atmosphere Noxious to Health, Section 283 IPC, Obstruction in Public Way, common in encroachment cases, Section 290 IPC, Punishment for Public Nuisance, Section 291 IPC, Repeat Offenders of Public Nuisance. The CrPC acts as the mechanism for police to arrest, magistrates to try, and courts to penalize environmental offenders under these IPC sections. The role of police and executive magistrates under CrPC. Police powers under CrPC. Section 149-153, Prevent cognizable offenses relating to environment. Section 154, Register FIR for environmental offenses under IPC or special acts. Section 91, Seek documents or evidence from polluting industries. Magistrates' role. Pass restraining orders. Conduct summary inquiries. Take suo motu action upon complaints. Evoke public trust doctrine via Section 133 and 144. Via limitations and criticisms. A. Procedural bottlenecks. Requires proof of public nuisance or imminent danger for Section 133 or 144. Delay in court proceedings reduces preventive efficacy. B. Limited awareness. Local magistrates and police are often unaware of their environmental powers. C. Lack of coordination. CrPC lacks specific mention of environmental standards. Hence, coordination with pollution control boards is essential but often missing. D. No provision for environmental compensation. CrPC does not cover civil remedies like compensation for environmental damage. Seventh, suggestions for strengthening CrPC's environmental role, training of magistrates and police in environmental laws, integration of CrPC powers with NGT and PCB mechanisms, legal awareness among public on how to file Section 133 complaints, time-bound proceedings in urgent environmental matters under CrPC, FATIS case studies. Case 1, Vardichan Vezratlam Municipal Council, 1980. Waste and excreta flowed into the street and open drains endangered public health. Supreme Court used Section 133 CrPC to direct the municipality to construct drainage and sanitation systems. Significance: demonstrated judicial creativity in applying criminal procedure for environmental justice. Case 2, Katrulal Bhagirath Agrawal vs. State of Maharashtra, 2005. Case concerned illegal pollution of a water body by chemical effluents. Court upheld criminal prosecution under IPC read with CrPC provisions. Case 3, G. Vasu v. the State of Kerala, 1986. Noise and dust pollution from illegal quarrying. Court used Section 133 to restrain quarry operations. Met. Conclusion. Though not an environmental code per se, the Criminal Procedure Code CrPC serves as a potent legal instrument to combat environmental degradation by preventing hazards through immediate magistrate orders, prosecuting offenders under nuisance laws, supplementing special environmental statutes when urgent action is needed. Its success, however, depends heavily on awareness, proactive magistrates, supportive police action, and citizen engagement. With judicial backing and proper training of enforcement personnel, CrPC can become a grassroots tool for environmental governance and public health protection. For Public Interest Litigation, PIL for environmental protection. Introduction. Public Interest Litigation, PIL, is a unique and powerful tool developed by the Indian judiciary to allow access to justice for individuals and groups whose rights may be infringed, but who may not have the means to approach courts. It is especially significant in environmental matters, where the harm is often diffuse, long-term, and affects entire communities rather than individuals alone. Through PILs, the judiciary has played a proactive role in environmental governance, recognizing the right to a clean and healthy environment as part of Article 21 of the Constitution, and issuing directives to government bodies, industries, and municipalities to address ecological harm. See Evolution of PEEL in India, Early Development 1980s 1990s. PEEL evolved as a response to the plight of the poor and marginalized and was pioneered by judges such as Justice P. N. Bhagwati and Justice V. R. Krishna Iyer. Gradually, it expanded to include environmental protection, beginning with cases related to pollution, forest conservation, displacement due to development, and industrial hazards. Present status. Today, PIL is a cornerstone of Indian environmental jurisprudence, allowing NGOs and citizens to file environmental cases, courts to issue writs, guidelines, and monitoring orders, public accountability of polluters and lax administrators. Three constitutional bases of PIL: A. Article 32 and Article 226. Article 32 empowers citizens to approach the Supreme Court directly for enforcement of fundamental rights. Article 2 and 26 empowers high courts to issue writs for the enforcement of both fundamental rights and legal rights. B. Article 21, right to life. The Supreme Court has interpreted Article 21 to include the right to live in a clean, pollution-free environment. Right to life includes the right to enjoyment of pollution-free water and air for full enjoyment of life. Subhash Kumar, State of Bihar, 1991. IV. Key environmental doctrines developed through PEEL. 1. Public Trust Doctrine. The state is the trustee of all natural resources. It cannot hand over common resources to private ownership without public good. Originated in M.C. Mehta vs. Kamal Nath, 1997. Do polluter pays principle. The polluter must bear the cost of environmental damage. Applied in Indian Council for Enviro-Legal Action vs. Union of India, 1996. 3. Precautionary principle. Preventive measures must be taken when there is potential for serious or irreversible environmental damage. Emphasized in Velar's Citizens Welfare Forum v. Union of India, 1996. 4. Sustainable development. Balance between environmental protection and developmental needs. Underpins many PL rulings. V. Landmark environmental PL cases in India. 1. M.C. Mehta v. Union of India, Ganga pollution case, 1988. Factory effluents were being discharged into the Ganga. Court ordered closure of tanneries and industries not adhering to pollution norms. This PIL expanded the scope of environmental accountability. 2. M.C. Mehta v. Union of India, oleum gas leak case, 1987. After a gas leak in Delhi, court introduced the absolute liability principle, holding hazardous industries liable even without proof of negligence. 3. Rural litigation and entitlement. Kendra vs. State of UP, Dehradun quarrying case, 1985. PL against limestone quarrying in the Mussoorie Hills. Court stopped mining to protect ecology. First environmental PIL emphasized the right to healthy environment. 4. Vellore Citizens Welfare Forum Work Union of India, 1996. PIL against tannery pollution in Tamil Nadu. Recognized and enforced precautionary and polluter pays principles. 5. T.N. Godavarman Tirumulpad Verge Union of India Forest Case, 1996 onwards. Ongoing PIL that led to ban on tree felling in protected areas. Creation of Compensatory Afforestation Fund. Constitution of Central Empowered Committee, CEC. Procedural aspects of environmental PIL. A. Who can file? Any public-spirited individual, NGO, or citizen group. No need to show personal injury or loss. B. Where to file? High courts under Article 226. Supreme Court under Article 32. C. Forms of relief granted. Writ of mandamus to authorities. Injunctions and stays against polluting activities. Monitoring committees, e.g. CEC, NERI inspections. Compensation to affected communities. Directions for environmental impact assessments. 7. PIL and role of judiciary in policy formation. In many cases, courts through PILs have stepped into the role of environmental policymaker due to legislative or executive inaction. Examples: ordered use of CNG in daily public transport, introduced eco-sensitive zones around national parks, declared certain rivers and forests as protected zones, directed closure or relocation of polluting industries. Though effective, this judicial activism has also drawn criticism for overstepping into executive functions. Weight, criticisms, and challenges of PIL in environment. 1. Judicial overreach. Courts sometimes issue broad guidelines without administrative feasibility studies, risk of infringing separation of powers. Though misuse of pill, some PLs are filed with ulterior motives, e.g., blocking development. Courts now scrutinize the bona fides of pill petitioners more closely. 3. Implementation gaps. Even after favorable judgments, implementation is weak due to lack of political will or bureaucratic inefficiency. 4. Delay in disposal. Environmental PILs may remain pending for years due to complexity and multi agency coordination. 9. Integration with other legal mechanisms. National Green Tribunal (NGT). While PLs are still filed in high courts and Supreme Court, many are now redirected to the NGT, a specialized forum for environmental matters. BRTI and PL. Many PILs are based on information gathered through the Right to Information Act 2005, enhancing transparency and public accountability. Conclusion. PIL has emerged as one of the most significant innovations in Indian legal history, especially in the domain of environmental protection. It has democratized access to environmental justice, brought environmental concerns into mainstream legal discourse, catalyzed development of core environmental principles, held both government and private actors accountable for ecological harm. The Indian judiciary, through PIL, has expanded the scope of Article 21 to include environmental rights, introduced innovative doctrines, and shaped ecocentric jurisprudence. While challenges remain, PIL remains an indispensable instrument of environmental democracy in India. Do like and subscribe for more videos, and don't forget to check out the other videos on this channel as well. In the next part 3, we will continue with the remaining important topics. The Environment Protection Act 1986, the Indian Forest Act 1927. Please like, share, and subscribe. Thank you for watching.